Good morning. Are you Junius Vital? And this is 25 DCCR 1374. Mr. Vital previously was here, entered a plea of guilty to the third-degree felony offense of failure to comply with sex offender registration requirements. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Judge.
Any additions or corrections?
None that I'm aware of,
Not
Judge.
from the state.
All right, Mr. Parker, you may proceed.
Your Honor, Mr. Vital, he's, as far as I understand, he's done a pretty good job reporting for the last 10 years. He's lived around here, and he's also lived in the Houston area. I think the Houston was the last place that he was registered properly. He ended up going to a place called the Wheelhouse. I know it's called the Wheelhouse.
Yes,
in Deer Park area. He tried to register there, but he wasn't actually a resident. He was doing jobs out of there, but he was living in his car. And then when they denied him because of city ordinance, that's why he couldn't live there, city ordinance rules. Then he appealed it, and it still got denied. And then he applied. He was going back and forth between his sister's house in Beaumont and working there in Houston. And you tried to apply here in Beaumont as well on.
That's where I'm registered at Beaumont.
And
So where are you registered right now?
My sisters keep them folks in Beaumont.
In Beaumont.
Yes, ma'am.
And that's where you're living and you are properly registered at this
Yes,
time.
ma'am.
and I believe he's had some issues in the past. He had a substance abuse issue. He's done well with that. I think, he's not one that just ignored what he's supposed to do. I think he's tried, which is way more than I can say for a lot of people. And we're asking the court to give him probation, Judge.
Mr. Smith?
Judge, the state's going to argue for 4 years in prison in this case. The nature of the previous aggravated sexual assault of a child, I think the facts were fairly aggravating, and he was given probation initially, wound up getting revoked when he committed a new offense, and was revoked and sent to TDC for a 30-year sentence and then a 20-year sentence. It looks like even the PSI notes that even though the criminal history is limited, the circumstances of the offenses are severe. He was given probation in the past that resulted in revocation, and looks like he does try to justify his actions in the PSI interview.
I may respond.
Hold on, I just wanted to, when did you parole out? How long have you been out?
2015.
2015? And so since 2015, there haven't been any issues with reporting and it looks like, so while you were since you've been on parole, you've also gone to ISF, correct?
Yes, ma'am.
Okay,
That's why I was still in parole. I discharged in 2022.
you did?
Yes, ma'am.
And I would just like to say that, part of his revocation was, as according to him, and I think the probation officer, with substance issues. And I think that's part of the reason why he did.
This is the moment where the hearing shifts from background history to the judge's personal evaluation of the defendant's credibility. Rather than focusing only on past convictions, the judge carefully questions what has happened since the defendant's release, asking whether he has remained compliant and whether his explanation matches the evidence before the court. At the same time, the prosecution continues emphasizing the seriousness of the underlying offenses, while the defense argues that years of reporting and efforts toward recovery deserve meaningful consideration. Cases like this often involve balancing public safety against evidence of rehabilitation, making the judge's questions especially important. What do you think matters more in a sentencing decision, someone's past record or their recent behavior? Keep that question in mind as the hearing returns to the courtroom and the judge continues weighing every detail before making a final decision. By the end of this hearing, it's clear that the judge is looking beyond arguments alone and wants objective confirmation before making any final assessment. Instead of relying only on statements from the defense or prosecution, the court orders a drug test, reinforcing that accountability and verification remain central to every decision. Throughout the hearing, both sides presented competing narratives, one emphasizing years of compliance and personal progress, the other stressing the seriousness of the defendant's criminal history and the importance of protecting the public. Those competing perspectives are exactly what make courtroom proceedings like this so compelling, because every ruling depends on the evidence presented in that moment rather than emotion alone. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
That's where we are. I mean, she showed the document to me today, and I'm trying to get her to get the victim to go, or not the victim, this person to go to the DA's office and sign the document in front of them. And that should resolve the case, but I can't.
Both cases?
Both.
So I mean, this is going to be the last reset. So either they go up there and do what they've got to do. They've got to go to the district attorney's office to do that. You can't just take something for them. They have to go do it. Okay. And if they don't, then when we come back, we'll have to work something else out. All right.
And don't-
This will be the last one.
Don't wait till day before court because, okay, well, I'm just telling you.
Talk to them and tell them if they don't go take care of this soon, then it's going to be you having some issues here in court next time. Okay. All right. You're free to go.
Thank you, Judge.
Thank you, sir. Mr. Rojas, you got Terrence Currington, the sentencing. Terrence Currington.
Yes.
Good morning. Bond will be forfeited for non-appearance and reset at 100,000. If you can get in touch with them and get them here because it's an agreed probation, so
Probation's good.
I'll consider recalling that forfeiture if he shows up.
Thank you. Nice day. I apologize. Yeah, she's.
Mr. Lewis, you've got Devontre Johnson.
Yes.
Devontre Johnson. Good morning. Are you Devontre Johnson?
Yes.
And this is 25 DCCR 04-8. Mr. Johnson is charged with failure to comply with sex offender registration requirement. And what is the announcement?
Judge, notes on Ms. French's file show that there is a new fair to register case that's in intake right now. So she has withdrawn the 5-year cap offer that she made.
Okay,
So we request a reset.
so that
for
one
the new
should,
case again.
okay, but it's already there and it can get taken care of before that next court date, I'm sure.
Yeah.
If you'll make sure they know. So what I'll do is I'm going to reset your case about 30 days. It sounds like there is a new charge that could be indicted between now and then. Stay in touch with Mr. Lewis so that he can then get the information on that one, get a new offer from Ms. French, and we'll see where we are at the next court date. All right, you're free to go. Mr. Paget, you have Catherine Bautista.
I thought paperwork, Your Honor, just said paper chest.
Okay, I'll call it in just a second.
You don't mind.
Mr. Samuel and Deanna Paul,
I just had her wait outside and visit with prosecutors.
I'll hold it.
Thank you. Yes.
So do I need
Okay.
to call this one? What is it says, there's that from
Just to let you know, and at this time, that's, I came, all right. Just to let you know, it has This one.
Like make, and then check mine too. May check mine. Okay, gotcha. Oh, no, that's fine. Marvin, David? Hey, Mr. Kevin Lane, on, Sean Dage, is the sentencing? Good morning. Are you Sean Dage? And this is cause number 24 DCCR 2353. Mr. Dage was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has your honor.
Yes, Judge.
Are there any additions or corrections?
None from defense.
No, that's that.
What? So I guess what I'm trying to figure out is the additional case. Was there an assault
Your honor,
filed also as part of this?
It was not filed, Judge.
it was refused, your honor, according to the report, and it's hotly contested on the defense.
Okay. Okay. So that's the burglary that was refused.
Yes, your honor. And I know there's a recitation of the facts but those are hotly contested.
Okay. All right. Well, then, I mean, obviously the criminal history gives me a whole lot of concern. And whatever went on that night shouldn't have happened. So. I mean, I don't understand. In 2019, there was an evading arrest or detention with previous convictions, and he got a 4-year TDC on it. So I guess.
The initial offer was for time in this case, Judge, after lengthy discussions with Mr. Lane and the fact that underlying case was refused. I came down with a probation. We will respect your opinion on this.
My only brief retort, your honor, is these are evading on foot.
But you don't get to keep doing it and then get rewarded for continued bad behavior, right? You don't go to prison for something typically and then get a better deal the next time you do the same thing. You see how that doesn't make sense to me and to most people?
And your honor, brief argument, we are asking the court to follow the agreement. Mr. Diggs does have a lifestyle and a plan, work and paying child support, a life now that does not seem like anything that the court is reviewing now. The court does have the mechanism, of course, to really put them in jail for a long time. The moral recognition therapy could work. Any other type programs the court may have. We believe he can do it.
I mean, and so I guess the case is from 2024. Have you been out since then on bond? And I got the letter, and I'll take judicial notice of the court's file. It does include a letter that was sent over by your attorney from Mr. Peterson, who I used to work with. and trust and value his opinion greatly. And he sent a very supportive letter about you working in that office building and that everyone valued you there. So obviously, maybe you finally figured it out because the criminal history doesn't look like it, but you're older now. A lot of this was when you were younger, but you got to realize that it doesn't matter if you get scared. It doesn't matter what you're doing. If a cop says they want to talk to you for any reason, you would have been talked to them and not been here in felony court if you hadn't ran, you know? So being scared isn't an excuse anymore. Because if something happens, if I go follow this probation, and something happens while you're on this probation, you're looking at the 10-year sentence that you've already agreed to. No negotiations, 10 years in prison. Do you understand? All right, then I'm going to find that you entered your previous plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Also find the prior offenses, convictions true that you pled true to. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. The order to pay the
6 years, Judge. It's 10
sorry.
probated for 6.
Okay, sorry, the PSI has it as 10.
That's right.
So that would have been one of those corrections.
Yes. I
That's
apologize,
for-
Ron.
6 years probation. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. It sounds like this shouldn't be a problem for you. It's just following the rules, go into probation, do your community service, keep working, and you should be fine. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and your probation can be revoked and you would be facing that 10-year sentence that you've agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lane. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Thank you.
Would you turn that video down and see if maybe it'll kick on?
Terrence Harrington is around. He was earlier on the
Okay,
docket.
thank you. I know, I just feel like it's getting stickier and fire. Let's see, okay. I'm kidding there. I already called it and he asked me to wait. Deanna Paul, Mr. Samuel.
Perhaps so.
Yeah, I just visited with the prosecutor.
Hold on, let's get everybody.
Okay.
Thanks. I said thanks.
Oh. I mean, he's.
Good morning. Good morning. Are you Deanna Paul?
Yes, ma'am.
And this is 25 DCCR 1792. Ms. Paul's charged with stalking. And what is the announcement?
Your Honor, I've spoken with the prosecutor. We reached an agreement. We'd like to reset and come back, take care of that.
So it will be up for a plea. I can put it on the plea docket.
Yes,
So Ms. Paul, I'm going to reset your case to the plea docket and we'll get your plea taken care of on that next court date. Stay in touch with Mr. Samuel. He'll let you know when you need to be back. You're free to go. Thank you. And is Mr. Rojas, you've got Terrence Purrington. I understand he's
Can't tell you what the down the hall is.
all right. I'll recall that bond forfeiture. All right, sir. You're Terrence Purrington?
Good.
And so, Mr. Purrington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right. Mr. Purrington was previously in court and cause number 25 DCCR 1114. Entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
we have your own district.
Any additions or corrections?
Not from defense.
All All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct? Okay, so here's the thing. If you have that card, you can only use what they give you and the amounts that they give you. Right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
That's not good.
They didn't charge you with it, but they found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it?
Really?
It is. That's how they give it to you in little plastic baggies.
No, that's, you see.
She's asking if the stuff they.
I'm asking you.
Is that from-
What? Here's the thing. I'm sorry.
He's in the bag. Plastic bag.
Is that how they give it to you?
Oh,
Okay.
you just put it in there
Why would you do that?
for the smell.
For the smell?
This
To block the smell?
right.
Well, if you've got a card, then why are you trying to block the smell?
But I just don't want to be right now. Smell like
Well, how about don't keep it in your car at all?
that too.
That too.
It's-
So here's the thing, having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of your probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork. Mr. Burbank, you've got Rakeem Allen, 3 cases. Good morning. Are you Rakeem Allen? Speak up, please.
Yes, ma'am.
And this is cause numbers 25 DCCR 1163, 1164, and 1697. Mr. Allen is charged with evading arrest or detention with the use of a vehicle and 2 cases of possession of a controlled substance. Mr. Burbank, what is the announcement?
Your Honor, I've been talking to Miss Chase about this. Mr. Allen and I had a communication problem in the last couple of weeks. It looks like we have corrected it. It had nothing to do with witnesses, but actually getting in contact. I would ask for one more reset, Judge, to see if we can't offer this 10 years or 12-year cap. And I was talking to Miss Mofino about another option.
Mr. Allen, do you have the drug patch? Don't see the most recent results, and so I'm going to have you have a seat in the jury box and let's get a test this morning just because I don't have the most recent results. The last one I have was positive.
Well,
That's fine.
We've got probably 10 positives on him ever since he first got these cases. He keeps finding out. So I was going to ask you to test it. Thank you.
Thank you.
He must be in the election.
Oh, yeah,
Right.
I remember this. That's unfortunate. Okay. Tiana Hughes, Mr. Burbank.
Yeah, this year's.
Good morning, ma'am. Are you Tiana Hughes? And this is 25 DCCR 1058. Ms. Hughes is charged with credit or debit card abuse. And Mr. Burbank, what is the
I
announcement?
hate to tell you just one, a reset, this would be dispositive, needs to get her money together. She had, had some problems with the bank and some other stuff, reference straightened out. But she has, corrected that. So if I just get a normal reset, it should be finished next time.
Okay, so any issues?
No, Your Honor.
All right, we'll just do a normal reset, Ms. Hughes. Make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back for that next court date. Okay, you're free to go. Cody Litchfield. Good morning, you're Cody Litchfield. And this is cause number 26 DCCR 0646. Mr. Litchfield is charged with attempt to commit arson. And Mr. Burbank, what is the announcement?
I am not finished with discovery. I'm trying to get some video of this, through the fire department in the county. And so that's where I'm at.
Any issues, Mr. Nichols?
No, Your Honor.
All right, we'll just do a normal reset. Mr. Litchfield, stay in touch with Mr. Burbank. He'll let you know when you need to be back.
You're free to go.
You're free to go. And Crystal Robertson. And then don't leave after you're done when I've mentioned something. This is Mr. Coleman's case on a Crystal Robertson. Good morning, ma'am. You're Crystal Robertson.
Yes, ma'am.
And this is 25 DCCR 1526. Ms. Robertson is charged with forgery of a governmental instrument. And what is the announcement?
Your Honor, she is in between jobs. What I mean by that is she has a job, she's just gotten a better job, and there is a bonus. She's going to a government entity. This is a case of restitution and then solution for final disposition. So I would ask Judge, and that was the intent of the prosecutor and myself, so that we can get this by her so that she doesn't have any felony.
When do you anticipate?
July.
Okay, so we'll just do a normal reset.
Yeah, sure.
And so, Ms. Robertson, I'm going to reset your case normal about 30 days or so. Stay in touch with Mr. Burbank. He'll let you know when you need to be back. All right.
Okay. I think that's all.
Is why he didn't.
Well, yeah, I mean, it was revoked a year after based on a possession case. And that, I mean, I don't disagree with Mr. Smith, but the criminal history, I mean, we're talking about 1991, 1993. We've had 11 years of reporting, and the wheelhouse is somewhere. I understand you're trying to get some help and do some good things, but you understand you can't do that if you can't.
Yes, ma'am.
You have to be able to be somewhere where we know where you are
Yes, ma'am.
and that you're properly registered.
And that's when they went and denied me out there.
Go ahead.
When they denied me out there, you know what I'm saying, I talked to them. And when I came, I said, I'm just going out there and going, you know, register, you know, back in Beaumont. And then I was still trying to, you know, continue, you know, so working the program.
Right.
Drug control program.
So are you clean now?
Yes, ma'am.
Just double check that this morning, okay? Have a seat in the jury box. I'm gonna have you drug tested this morning. Mr. Parker, you've got Regina Williams, 2 cases.
But yeah, Joe,
I'm sorry.
I haven't done any paperwork on it, but. This is Ms. Malfino's case. We're supposed to be providing Ms. Malfino with an affidavit. We have a copy of the affidavit, but it hasn't been signed. I told her that the person needs to actually go to the DA's office to present it to them. So